Hello and welcome again. Before resuming, just a note in passing as to what is meant by the term Privy Council, mentioned in the last talk. It refers to a group of advisors to the monarch, comprising highly ranked parliamentarians, for example ministers, and legal experts. Privy councillors are thus charged with ensuring that the monarch is given sound advice when considering serious constitutional or state matters. Now let's take up where our last discussion paused, which was on the issue of the right to bear arms, guaranteed in the Constitution and the Bill of Rights. In Australia, this right has been seriously eroded by unconstitutional legislation. But the situation in Britain is more peculiar. One of the signatories to the Magna Carta Society's submission to Leland Price QC was Mike Burke. He went to the Court of Appeal on the 8th of March 1998 in support of his case based on Clause 7 of the Declaration of Rights 1688, permitting him to bear arms in self-defence. His appeal was rejected. Despite further inquiries and research, he still waits for an answer to the question, where exactly did the learned judges in the High Court and the Court of Appeal discover authority for the removal of the right to arms and the repeal of at least one clause in the Bill of Rights? Recalling that the Bill of Rights was never enacted and thus stands, like Magna Carta, as a treaty, immune from parliamentary amendment and interference, this question goes to the core of the integrity of the judiciary in their role of upholding due process and the rule of law. Even more bizarre, however, is the fact that subsequent searches of legal records have revealed no trace of the judgment rejecting his appeal. The obvious question is, why not? If the judgment is sound, why is it not part of the body of precedents which comprise what most people regard as the law? Does this not raise important questions about the suppression of rights by stealth, this time with the connivance of the judiciary? The Magna Carta Society notes somewhat somberly that the last time Britons were forcibly deprived of the right to bear arms, the result was the American War of Independence. As George Orwell noted, all tyrannies rule through fraud and force, but once the fraud is exposed, they must rely exclusively on force. An implication of this is that those who know or have learned of the law as it now stands under Article 61 and still decline their constitutional duty to swear their oath to the Constitution, for whatever reasons, will sometime have to confront the fact that the numbers of those exposing the current fraud is growing, and that eventually the regime will either have to succumb to a debilitating lack of support or consent, or resort to the use of force as Orwell predicted. Inevitably, these reluctant ones will one day have to make their choice to stand or submit. The option of sitting on the fence will be gone. The Magna Carta Society then turns its attention to the Parliament Act 1949, which purported to enable legislation to be enacted after a year, irrespective of the opinion of the House of Lords. Constitutional experts contended that this act was not valid, the main reason being that, as Professor Hood Phillips pointed out shortly afterwards, it was rejected by the House of Lords, and the Parliament Act of 1911 had conferred no power on the House of Commons to amend the Constitution, thus crippling the Act as it left the starting gate. It follows from the invalidity of the 1949 Parliament Act that much of the subsequent European-led legislation must also lack validity, particularly the European Parliamentary Elections Act 1999, which of course purported to enable the European Parliament to exercise an increased degree of dominion over Britain by virtue of placing some Britons in situ during its pontifications. It's reminiscent of the 19th century situation when, in order to annex Ireland as part of the United Kingdom, influential Irish leaders were persuaded to concur by the offer of 100 parliamentary seats at Westminster. That move was of course opposed by Irish patriots, but was carried through, and it took several decades until there were a series of close-run elections featuring Gladstone and Disraeli in the 1870s, before those Irish MPs were given the power to unseat the government by voting as a bloc against proposed legislation on the floor of the Commons. At that point, serious agitation began for Home Rule for Ireland. But as we know, the unlawful dominion of Britain over her neighbouring state was upheld by political subterfuge until eventually the Irish won their independent free state by resorting to guerrilla warfare and forcing the British to the negotiating table, just as had the American patriots almost 150 years earlier. Yet another reference to the famous Santayana dictum about those who forget the past being condemned to repeat it. The Magna Carta Society noted that the House of Commons had repeatedly tried to interfere with the Constitution, noting that an attempt had apparently been made, called the Statute Laws Repeal Act, to repeal Magna Carta in 1969 during the distraction of the moon landings. It repealed Edward I's confirmation of the Great Charter Act of 1297, a source of one of the duplicitous arguments put forward by seditionists that Magna Carta has been repealed. However, the legal position is that repeal of an act that gives effect to a common law does not repeal the underlying common law itself. Neither, it notes, does the difference in time between the distance in time between the two events exercise any sway. Paradoxically, if Parliament could be held to have repealed Magna Carta, it could also be held to have acted unlawfully, since by definition it must have exceeded its powers by doing so. Some parliamentarians were aware of their responsibilities, or at least paid occasional lip service to them in various pronouncements. In 1993, on July 26th, for instance, the Speaker of the House of Commons stated, quote, "There has, of course, been no amendment to the Bill of Rights. The House is entitled to expect that the Bill of Rights will be fully respected by all these things appearing before the courts," unquote. Unless, apparently, one is named Mike Burke and wishes to exercise one's right to bear arms. Lord Wilberforce in the House of Lords in 1997 said this, quote, "Perhaps I may remind noble lords of what our essential civil rights, as guaranteed by common law, are. The presumption of innocence, the right to a fair hearing, no man to be obliged to testify against himself, the rule against double jeopardy, no retrospective legislation, no legislation to be given an effect contrary to international law, an old principle that has been there for years, freedom of expression and freedom of association, firmly secured already by the common law of this country and not intended to be superseded or modified by new interstate obligations," end quote. Fine-sounding words, but emphasised more in the breach than by their utterance, it would appear. No one has said it better than the great John Locke when he wrote, quote, "A ruler who violates the law is illegitimate. He has no right to be obeyed. his commands are mere force and coercion. Rulers who act lawlessly, whose laws are unlawful, are mere criminals," unquote. Are the traitors in Canberra, or indeed here in Western Australia and other states, busy as they are in selling away our freedoms for their own pecuniary gains, in any way exempt from this condemnation? It cannot be argued cogently that they are. There are indeed strict limits to what Parliament can do. Otherwise, as the Magna Carta Society notes when referencing the views of a lawyer who had made a special study of the EU's Corpus Juris body of law proposals, quote, "If any government believes it can do as it wishes without the constraint of a constitution which is enforceable, then no one and nothing is safe," end quote. Some of the things Parliament cannot do are: it cannot sit for more than its allotted term, nor permit anyone not elected to speak in its chamber, or anyone who has not sworn an oath of allegiance. It cannot dissolve itself, nor can it legitimately depose the monarch. It cannot bind its successors as by passing, quote, "unalterable laws." Even more importantly, it cannot legislate in contravention of the treaties which establish the Constitution and sovereignty of the nation, a point absolutely central to the case of the Magna Carta Society. Furthermore, it is obligated to protect the rights and freedoms of the people who elected it. It cannot complete the passage of a bill without royal assent. The sovereign, conversely, can dissolve Parliament, with or without the advice of ministers, and withhold royal assent. Only the sovereign can call for new elections, and only the sovereign can sign treaties. These powers can from time to time be delegated, but they essentially embody the supremacy of the sovereign over Parliament. Because the sovereign is constitutionally bound to respect the provisions of the Bill of Rights, such royal prerogative has restrictions. For example, it cannot be used in an innovatory fashion, such as dispensing with Parliament and the judiciary, and thus becoming an unlimited tyranny. Were this permissible, any future Attorney General could claim that an edict was part of a treaty, and it would become unquestionable. Another restriction is that it cannot be used to subvert the rights and liberties of the subject. In Nichols v. Nichols 1576 it was ruled, quote, "Prerogative is created for the benefit of the people and cannot be exercised to their prejudice," unquote. Prerogative may not be used to suspend or offend against statutes in force. This comes from the Bill of Rights and the Coronation Oath Act, which specifies the following form of words. Archbishop, quote, "Will you solemnly promise and swear to govern the peoples of the United Kingdom and other Commonwealth dominions according to their respective laws and customs?" End quote. Prospective monarch, quote, "I solemnly promise so to do," end quote. The limitations of royal prerogative are clear. The Lord High Chancellor Command Paper 3301 1967, subtitled Legal and Constitutional Implications of UK Membership of the European Community, states, quote, "No prerogative may be recognised that is contrary to Magna Carta or any other statutes, or that interferes with the liberties of the subject. The courts have jurisdiction, therefore, to enquire into the existence of any prerogative, it being a maxim of the common law that the king ought to be under no man but under God and the law, because the law makes the king. If any prerogative is disputed, the courts must decide the question of whether or not it exists in the same way as they decide any other question of law. If a prerogative is clearly established, they must take the same judicial notice of it as they take of any other rule of law." End quote. The Magna Carta Society then argues that while sovereigns have, over the centuries, sometimes delegated the royal prerogative to sign treaties, to plenipotentiaries to act on their behalf, such devolved power is strictly limited and cannot be used to remove the freedoms and liberties of the people by imposing foreign government and foreign law on them. In other words, the signatories of the European Communities Act 1972 exceeded their powers under the royal prerogative. They further argue that the subsequent claims made by government ministers and officials that European law is supreme in the UK is wholly ill-founded. At least one lawyer, they point out, has suggested that anyone making such a claim is either ignorant or lying or bluffing or admitting illegalities or perpetrating a combination of all four follies. At this point, the submission moves on to the issue of the basis of legal sovereignty, which is where we will resume next time. Thank you for watching.